Welcome to Estate Planning, how to protect your home, family, and savings from costly mistakes. I'm Robin Goldenberg. I am an attorney at the law offices of Pasternak Apel, and today we're going to talk about estate planning and how to protect yourself and your family. A little bit about me. I am the co-director of the estate department and the chief operating officer at the firm. I oversee the estate planning practice, and I focus on estate planning strategy sessions where I meet with clients and we come up with a plan to help protect their assets and ensure that their families are protected when they're no longer here. A little bit about the firm. We are very unique in the sense that not only do we do estate planning, but we also do estate administration, or what you may know as probate. When somebody passes away and they have a will, it has to go through probate. If they don't have a will, it goes through estate administration. We do both of those, and we do estate litigation. And so what makes us really unique is a lot of firms out there will do estate planning and estate admin, but they don't do estate litigation. So we see the problems that happen when families are fighting because a document may be defective, or because there is some claim of undue influence or incapacity. And so that helps us in our estate planning because we see what actually ends up going to court. So we know how to best plan around to protect against that. We also do real estate, commercial, residential, land use, and we do litigation from anything from commercial to consumer fraud litigation with regard to residential real estate. And we also do business where we are the general counsel for a number of businesses. So what's the goal of this workshop here today? Well, we're going to identify the types of estate planning. We're going to understand what it takes to protect your home, your family, and your assets, but we're going to call it stuff because assets sounds really formal, but really it's just what does it take to protect your stuff. And we're going to talk about what you may have and what may be missing. So why do people do estate planning, right? What are the goals of estate planning? Well, many people say they want peace of mind, they want family harmony, but there are other goals. So there is the attempt to maintain control during your incapacity. So if you are incapacitated, many people want to make sure that their wishes are being carried out and that they're not taken advantage of, which is a huge part of estate planning. We want to make sure that we have easy wealth transfers at death. We want to protect our beneficiaries from others and often from themselves, especially if they have drug or alcohol or gambling issues. We want to be considerate of long-term care protection. Where are we going to be in the future? How are we going to pay for long-term care? Sometimes people have blended families where they're on second or third marriages and there's children from different marriages or different relationships that they need to protect. And then there's asset protection and taxes, right? No one wants the government to get all their money, so people do estate planning to protect assets and minimize taxes. So what is asset protection when we say that, right? Well, you're going to protect you and your family from lawsuits, creditors, predators. You want to gain safety and security. You want to have peace of mind that your family's going to be okay when you're not here. So who are the predators, right? Who are the people that are coming after your money? Well, there's really four types of people or entities that come after your money. One is the government. The second is long-term care costs. Third is your family, and then the fourth is taxes, which I guess is another form of the government. So who in the government is coming after your money? So if you don't have the proper documents in place, you are going to need a guardianship. And we're going to talk a little bit more about what guardianship is, but basically you have to go to court and somebody has to tell the judge or explain to the judge that you are incapacitated and you're no longer able to make decisions for yourself. And then they will get appointed by the court and get access to all of your finances and access to making decisions on your behalf. When you die, if you are dying with a will, you have to go to court through probate. If you die and you don't have a will, you also have to go through court in the same place, which is the surrogate's office. And then the government obviously there are estate and inheritance taxes. Estate taxes can be as much as 40%. So it's really important to make sure when you're planning that you are addressing these issues. What about long-term care, right? How is that a predator? Well, the statistics are that 1 in 2 women and 1 in 3 men over the age of 65 will need nursing home care. The average cost in the state of New Jersey for nursing home care right now is about $15,000 a month. you can see how this could quickly wipe somebody out. People can stay in nursing homes for an average of 3 years now. It used to be that people weren't in nursing homes for a very long time, but now people can stay in nursing homes for a substantial period of time, and that's a lot of money. So how do you pay for long-term care, right? Well, there's really only three ways. You're either going to privately pay with your own money. You have long-term care insurance, which most people don't have, and even if you do have it, it doesn't protect against everything. Or you're going to try and qualify for Medicaid. And I'm sure you've all heard a little bit about Medicaid, but you have to, Medicaid is an income-based program that provides for long-term care. You need to have less than $2,000 in assets and $2,700 in income, usually per person. There are ways to deal with qualifying for Medicaid, even if you have a decent amount of money. There are pre-planning techniques where you can start planning now, and then there are crisis planning techniques. So long-term care is definitely something that you need to be aware of. And then there's family, right? We love our family, but they're not always the easiest people to deal with, and sometimes they have some issues. So when you are doing estate planning, you want to be aware of certain things. Remarriage, your remarriage, or maybe one of your children's remarriages, or maybe one of your children, you're concerned they may get divorced and you don't want all of your money if you die going to their spouse. What if somebody has a bankruptcy? Is your money going to be used to pay back all their creditors? Or if they have a drug or gambling problem or an alcohol or mental health problem, right? They may not be capable of dealing with money. What if they're disabled and they're on some kind of government benefits and they inherit money? Are they going to be disqualified? And what about financial aid? Is your inheritance from your parent considered part of the financial aid, or would it affect the financial aid that your child may get? And what about lawsuits? If you get into a car accident and you don't have a lot of insurance, is your assets going to be subject to a lawsuit? So these are all things that are important to think about. And then there are the infamous taxes that we sort of talked a little bit about already. Currently, there is a $13.61 million federal tax exemption. So what that means is if you have more than $13.61 million in assets, you're going to get taxed. If you have less than that, you're not going to get taxed. Well, that's great. Like, that doesn't apply to most people. So most people are in the clear, but significant change is coming. At the end of 2025, it is anticipated that this number is going to go down to 5 million, and when they adjust it for inflation, it's going to be somewhere around 6.5 to 7 million. So if you have $7 million in assets between your 401ks and your life insurance and your house, your family may be subjected to federal estate taxes, and that could be as much as 40%. So planning for that is really important. In the state of New Jersey, we have inheritance taxes. So depending upon your relationship with the decedent, the deceased person, would depend on how much you have to pay for inheritance tax. If you are a child, a grandchild, you're usually not going to have to pay inheritance tax. But if it's a niece or a nephew, they may. And New Jersey, while we currently have no estate tax, it wasn't that long ago where our estate tax was anything over $675,000, which is not a lot of money when you take into consideration, that you may be talking about your house as part of that, or a pension or 401k, right? So it wasn't too long ago where we were getting taxed in the state of New Jersey on estate taxes. So these are things you need to be prepared for and prepare against. So when was the last time you reviewed your existing plan, or do you even have a plan? Well, if you don't have a plan, if you don't have a will, or it's not done properly, then it's going to be the state's plan for you. So what's the state's plan for you, right? So the state's plan is that there is actually a law called the intestacy law, and it determines how and who gets money based upon the relationship for you. So if you are married and you have a spouse, but children from a different marriage or a different relationship, then your spouse is not going to get everything. So you need to make sure you plan appropriately. What most people tend to do is they plan for death, right? They do a one-time transaction. They get a will and they forget about it. I did it, I didn't look at it again. And those are the situations when it's not going to work for your family because you aren't keeping up with the times. Your relationship may have changed with people in your family. There may be people in your family no longer alive. Tax situations may have changed. Some of your heirs or your beneficiaries, the people you're leaving money to, may not be capable or competent enough to handle money. you may not have anyone getting some of your assets, and when you don't have anyone getting some of your assets, they may go to the Department of Unclaimed Property. So there is this Department of Unclaimed Property in every state, and I encourage you to go in there and take a look at some of your old family members and see what you can find. I have a grandfather who has some shares of some stock that we can't get because we have to prove that he lived at a certain place at a certain time. Like, I don't know how we're ever going to do that, right? So, but there's other people that we have found that had life insurance policies that were in the Department of Unclaimed Property, and we were able to go back in and claim it. So it's important that you make sure that you know what you have. So what we want to do is we want to plan for life, right? We always tell everyone you need to update your estate planning documents every 3 to 5 years, or at least review them, and then any life changes, birth, deaths, marriage, divorces. Those are things that require you to take a look at your estate planning. So we want to plan for what's going to work for your family when they need it. We want to make sure that they're well informed and they're empowered and that they're not paying all this money in taxes, right? So we want to make sure that we're making the best choice for our family to keep them out of court and to keep them out of conflict, right? And so we talked a little bit about, if you don't do this, the state has a plan for you. It's going to either consist of guardianship, where they're going to appoint someone. Maybe it's the right person, maybe it's not. You would be surprised who comes out of the woodwork when they find out that there's a guardianship hearing and they want to be the one that controls your money. Or you're going to go through probate, where the court's going to determine, based on the intestacy law, who actually gets money, not based upon who you wanted to get money. You may have a child you haven't talked to in years who's going to end up getting a substantial portion of your estate because you didn't have a will. So there's a quote that says, if you don't have these documents in place, you're basically going to file a lawsuit against yourself with your own money for the benefit of your creditors. And so that is no fun. So when you don't have the documents, we talked about this, intestacy law, guardianship, you're going to go to court, right? The court's going to determine who gets the money. The court's going to determine who's your guardianship. Do you really want the court, who doesn't know you, having that much power? It's a lot of power. And, while they try to do the best they can, it doesn't always turn out right. And so it's important that these documents will protect you from having to have that much involvement of the court. Let's talk about some famous people, right, where this has happened to. James Dean, right? He died at age 29 without a will. His entire estate, including all his licensing fees, which he still gets to this day, passed to his father, who had abandoned him as a child, because under the intestacy law, the person that was going to inherit was going to be his father. So his father, who abandoned him, and his family will get $1 to $3 million annually from James Dean's estate. Do you think he'd want that? Do you think he'd be happy with that? How about Marilyn Monroe, who died at 36? And she had a will, but her will left 75% of her estate to her acting coach, with wishes that he donate to charity. If you leave wishes in your will, you might as well leave nothing, because wishes don't have to be followed, right? So Strasberg later married, and at his death in 1982, his entire estate plus all of her licensing went to his widow, who she had never met. So her licensing generates $1 million annually, and that was going not to a charity, but to somebody she had never met. Prince, right? Some of his estate got settled this year. Some of it keeps going on and on and on and on and on. For almost 5 years, they'd been in battle in one of the longest drawn-out complex legal industries disputes. He had his business partners were involved, his heirs were involved, the IRS was involved. He had no will. And a lot of it revolved around the discrepancy over who was going to get what, and then how much everything was worth. When the IRS got involved, the IRS was saying, well, you guys aren't evaluating his stuff right. And we think that his music collection's worth $15 million more than you think it is, and his real estate's worth more, and his songwriting shares are worth more. And so they want it to be worth more, right? Because they're going to get more money. They're going to make out from this, because they're going to get 40% tax on anything that was over potentially $13 million, or whatever the federal tax exemption was when he died, which probably was a lot less than $13 million. And wouldn't it be fun to see the will of John Lennon or JFK Jr., Babe Ruth, or Jerry Garcia, Jackie Kennedy Onassis? Well, you can, because all of their wills went through the court process, because they only had a will, and they didn't have a trust, and wills are public. So you could actually go and get any one of these wills to see what was in it. So when we talk about estate planning, what documents do you need? So there's wills and there are trusts. There's all different kinds of trusts. There's revocable trusts and irrevocable trusts. So we'll talk a little bit about the difference of those. There's special needs trust if you are on government benefits. There is a financial power of attorney that will help allow someone to make financial decisions on your behalf if you become incapacitated. There's healthcare power of attorney, which allows someone to make healthcare decisions if you're incapacitated. Living will, which are your end of life decisions, and your HIPAA forms, which you sign those a lot now as well, giving people access to your medical care. So what is a will? Well, a will states your intention for the distribution of your wealth and assets, right? It designates an executor. It lists your beneficiaries, who's going to get what. It appoints a guardian for minor kids. It appoints a funeral agent in New Jersey that is responsible for making sure your funeral wishes are complied with, or making them if you haven't done it. But a will is public. It goes through probate. You have to go to court to get a will administered. It takes effect only upon death. And it again, like, it's public, right? So will set out your intentions and the executors, who's gonna be the person that makes sure everything is distributed. You're gonna pay your creditors. You're gonna do all kinds of things. But again, a will is public. And a will, even though you appoint a guardian, your kids could still even be at risk, right? So what happens if your guardian's your sister and you live in New Jersey, but your sister lives in California? And God forbid something happens to you and your spouse, and now your sister needs to become guardian, right? She's got to get to California. Where do your kids go in the meantime? Do you need a temporary guardian? What happens? Who has the documents, right? So even though you think your kids might be protected, they may not be. So it's important to make sure that you have the right things in place. So we hear the word trust, right? And trust is sort of like a posh, cool thing, right? Like, a lot of people like to have trust because they like to have a check that says, Mary and Joe Smith of the Mary and Joe Smith Revocable Living Trust, right? It sounds pretty cool that they can pay for things out of their trust. But a trust is the only real way that you can avoid court upon your death. But a trust is only as good as it's funded. So think of trust like a box. You got to put everything into the trust, or whatever you need to put into the trust, for it to be funded. If you don't put anything in the trust at the end of the day and you die with a trust, that's beautiful, but nothing happens, okay? So things that go into a trust could be, your bank accounts, your property, investment accounts, and then there are certain things that we don't ever put in a trust, right? Because there are too many tax complications or other issues that we don't keep in a trust. So a revocable living trust is a trust that can be amended, changed, or revoked. So we have this box, we put stuff in it, we can take it out, we can change it, we can throw it around, we can do whatever. People often use trusts to protect their beneficiaries. If they're minors, right, it's going to be held in trust till they're a certain age with different potential distributions. They may say, well, I want my kids' share going in a trust because I'm not a big fan of their spouse. And if I give it to them outright and they get divorced one day, well, then the spouse is going to get it. A trust can be its own thing, or it could be part of a will. Sometimes they're in wills called testamentary trust, but they don't need to go through court. And that's sort of one of the biggest benefits of a trust. Trusts are a little bit more expensive and a little bit more work at the beginning, but they save a lot of time and they save expenses at the end, meaning once you die. An irrevocable trust is a closed box. So you put things in it and you close the lid and you can't touch it, right? So we'll talk about that in a second, a little bit more about that. A lot of people are hesitant to do irrevocable trusts because they can't touch it, and they give up some control, right? So this is just a diagram about the difference between wills and trust and where they overlap, right? They both have beneficiary designations. You allow for revisions, allow you to leave property to minors. Wills are effective only upon death. Trusts are effective upon signing. So if you become incapacitated while you have a trust, the trust still takes effect and the trust will control. And so a will only happens when you are upon death. And the good thing with the will or trust, and that this is what sort of makes it unique, is that you can make it your own. Jack Benny, he left an unusual but touching instruction in his will when he died. Every day since he had gone, his wife had gotten one long stem red rose delivered to her home, and she then learned that he had included that in his will. And so every day, based on his will, one red rose was to be delivered to her for the rest of her life, right? I mean, that's a pretty cool thing to be able to do. And that's how you can make it your own, right? Make it unique to you. So we talked about the different revocable and irrevocable trusts. Remember, revocable, box is open, irrevocable, box is closed, right? So revocable has more flexibility. You can change things. Irrevocable can't be changed, right? It basically is often taking the assets outside of the estate. And the reason people do that is to avoid taxes, because it then doesn't become part of your estate. There are pros and cons for the irrevocable trust, because you give up control, but it protects assets from creditors and it reduces estate taxes. So there are definitely reasons, depending on the size of your estate, or if you're trying to apply for Medicaid and you want to start taking things out of your estate, without there being any kind of penalty, you may want to look into an irrevocable trust. All right, we're going to talk about our favorite friends, the Flintstones. Everybody remember the Flintstones, right? Meet the Flintstones. So we're going to talk about Wilma and Fred. So Wilma and Fred each have $1. It could be $1, it could be $1,000,000, it could be $10 million. It doesn't really matter, okay? Fred and Wilma start off with their own trust. Wilma has $1, or let's say $1 million, and she puts it into a revocable trust. Fred dies. His money goes into an irrevocable trust. Wilma is able to take the $1 million out and spend it on whatever she wants in her trust, right? Because it's revocable. She can change it, she can amend it, she's in charge, right? Fred's trust, the box is closed, and Wilma can't have access or control to it. So who's the trustee? Who's going to be in control of it? Well, it's going to be Pebbles, their daughter, right? So Fred's box is closed, and if Wilma wants something from Fred's box, she's got to go to Pebbles. So she goes to Pebbles and she says to Pebbles, "Hey, Pebbles, I want $20,000 from Dad's trust for a hot tub." And Pebbles says, "You don't need $20,000 for a hot tub. The one you have in your bathroom is perfectly lovely." And Wilma says, "Well, there was a line in the trust that said if I don't agree with what you're doing, I can remove you as trustee. So I'm going to remove you and put Bam Bam in as trustee," right? So when you are deciding these things, there's some flexibility that is allowed into who are designated as trustees. Well, let's say now, a new scenario, Wilma gets sick and she needs to go into a nursing home. The nursing home says, "We want the $1 million in the revocable trust that was Wilma's." Can they get it? They can, to pay for her bills. But let's say they say to Pebbles, "We want $100,000 out of that irrevocable trust." Well, if that money has been in there for 5 years, Pebbles doesn't have to give it to them because it's a closed box and Wilma doesn't have access to it. Wilma, from Fred's money, can get income on a yearly basis, and she can get principal if Pebbles thinks it's going to help with her education, maintenance, or support. Okay, let's say we're new scenario, Wilma's in a car accident and God forbid kills somebody, right? That $1 million in the revocable trust, they're going to be able to get access to. The $1 million in the irrevocable trust, they're not. New scenario. Wilma needs help cleaning the pool. And she hires somebody to come clean the pool, Biff, the pool boy. And Biff comes and cleans the pool. And he says to Wilma, "Wow, I could really, really use a trip to the Bahamas." Wilma says, "I'll get you a trip to the Bahamas." Now, Wilma could take the money from her own revocable trust and buy him a trip to the Bahamas. But when Wilma turns to Pebbles and says, "I need 10 grand to take Biff to the Bahamas," Pebbles is going to say no, because Dad said you can't get access to this money if you're going to go get married. And Wilma says, I'm not marrying this guy. I'm not going to get married again. I was married for 50 years to your dad. And she said, well, Mom, you better go read that trust, because the trust says Dad's definition of marriage is you go habitate with him for one day, and that's marriage. So I'm not giving you the money, right? So it's important what's in that trust and how the language is. And Wilma goes, oh yeah, I remember, because I didn't want your dad to use it for somebody else either. So that's why we had it set up this way. Now, Wilma and Fred both die, and they set up trusts for Pebbles with Bam Bam as a co-trustee, right? So Pebbles calls Bam Bam and says, Bam Bam, I need $300,000 for a condo. I want to buy a condo in Florida. Bam Bam goes, I'm not going to let you buy a condo in Florida. And Pebbles goes, well, then I'm taking you off as my trustee. And Bam Bam goes, no, fine, I'll buy the condo. I'll let you buy the condo in Florida. Well, who owns the condo? It's not Pebbles, it's this trust. The trust owns the condo, right? Well, Pebbles and her husband move to Florida and live in the condo, and her husband starts playing golf, and he's out all the time, and he meets this new woman, and he says to Pebbles, I want to get divorced, and I want, share the $2 million you got left by your parents. Does he get any of it? Does he get the house? Well, he doesn't get the house because the house isn't even in Pebbles' name. It's in the trust name. And he doesn't get any of the money because the parents left the money for her in trust. So it goes to her and her kids, not to him. So these are just some of the ways in which trust can help benefit somebody. One of the best uses of trust are with the blended family. Everybody remembers, the Brady Bunch, right? So what if Mike and Carol are married, and Mike wants to leave all of his money to Carol, but when Carol dies, he doesn't want it to go to Marcia or Cindy or Jan. He wants to go back to his sons, right? Can he set it up that way? Well, he might be able to, right? He's going to have some pretty pissed off daughters, but there are ways to do all of this, right? As a blended family, and trust are an important part of a blended family. Now let's talk about a financial power of attorney. What is a financial power of attorney, right? So financial power of attorney comes into play if you are incapacitated and you can't make financial decisions for yourself, or maybe you just don't want to make financial decisions for yourself, right? You're just too old, you don't feel like paying your bills anymore. And so you have your financial power of attorney do that, right? They make financial decisions. They get access to your bank accounts, your financial accounts. They can buy, sell, make loans, open credit cards, close credit cards. These are extremely broad powers, and there are a lot of them, right? A power of attorney is only effective to death. Then the executor or the trustee would have those powers. If you have a trust, the trustee gets some of these same financial powers of attorney during incapacity as well. They typically come into play if there's been an illness or disability. Sometimes people use them as real estate transactions. So in a totally different situation, I had a friend who was buying a house in New Jersey, and their in-law passed away, and the husband had to fly back to California to do to sign to be with his family, and the real estate closing was happening, and so he had to execute a financial power, a real estate power of attorney, a financial power of attorney that allowed his wife to sign on his behalf for the closing of the house. So you can do these for real estate transactions. If you have a financial power of attorney, you can manage retirement accounts. You can address tax filings. You can apply for or become the payer for Medicare and Social Security benefits. You can handle debt and credit cards, right? There's a lot you can do. The powers of attorney take effect upon signing, so it's important that you make sure the person who is your power of attorney you trust, otherwise they have access to a lot of documents. We just had a case where somebody was telling me a story about their landscaper managed to get power of attorney over an older woman who just wasn't really in the right state of mind and wiped them out, So that becomes very difficult to track these people down and prove that she wasn't in the right state of mind now that she passed away and that she didn't voluntarily do this. And it makes it very difficult. So you really need to trust whoever your power of attorney is. Powers of attorney are usually revocable. So if you picked somebody and you didn't like them, pick somebody else. Recently in the news, Jay Leno's wife was suffering from aggressive Alzheimer's, and he did not have a power of attorney for her, so he had to go to court and get conservatorship, which is what we would call guardianship in New Jersey, over his wife. Like, here's somebody who, has to know about estate planning, and maybe he himself has estate plans. I'm not real sure why his wife didn't want to have a power of attorney, but she created extra hoops for him to jump through. He had to get doctor's reports and go to court and testify and hire an attorney and things that wouldn't have been necessary had she signed a financial power of attorney. We also have healthcare power of attorneys or healthcare advance directives. And one of the things you really need to think about is, will your healthcare directive work when you need it, right? You want to make sure your wishes become directives. So let's think of, everybody remember Terry Schiavo? This was a case in Florida. This young woman ended up with like some illness, and her husband and her parents fought for like the next 7 to 10 years over whether or not she wanted to be kept alive with life-saving measures or not. It was an extremely sad case that went on for a very long time, and there were really no winners. It was very expensive, very emotionally draining. And she was young, so she didn't have these things in place, but everyone needs to have these in place, even kids that are like going off to college, right? So imagine you have an 18-year-old that goes off to college, and let's say, God forbid, they get into a car accident and they're unconscious, and their friend calls and says, Joey's was in a car accident, he's at the hospital, and you call. Guess what? They're not going to talk to you. So if you don't have a power of attorney, they're not going to talk to you because your kid's over 18. So it's really important to have these things in place. The healthcare power of attorney will help identify who the decision makers are and what your intent is, so that you can make sure that they are following it. It gives them access to talk to doctors, to make sure they're if you needed another surgery, they could consent to a surgery for you if you're under anesthesia. And then they are also responsible for making sure that your end of life directive, which you may know of as a living will, is in place. And living wills usually say that if you're at end stage disease or end of life, you don't want any life-saving measures in place. But you can add things to it. You can say, I don't want you to pull the plug for a week, and I want the last song to be playing before you pull the plug to be this. And if I'm going to be in that situation, I want there to be a party with M&Ms and chocolate cake everywhere, right? So these are things that maybe are your wishes, and whatever those are, they should be honored. So some of the other things that a healthcare power of attorney deals with would be emergency medical decisions, like we just talked about. If you're unconscious and somebody has to say whether or not you want a medical procedure or surgery or blood transfusion. We talked about the end of life care, right? Do you want life-sustaining measures? If you have complex medical conditions, if you're unable to communicate, if you have severe illness or dementia, they can help collaborate with your doctors to make informed decisions about you and your quality of life. They can consent to procedures. They can make sure that if you're an organ donor, that you are having your wishes honored. One of the important things when you're dealing with the healthcare power of attorney and the living will is to make sure that the person that you pick can actually make the decision and pull the plug, so to speak, right? It seems like an easy thing to do, but it is not. It is very difficult. And if you pick somebody because they're close to you, but they aren't able to do that, you're not going to have your wishes honored. So it's really important to make sure that you have your wishes honored. And then there's HIPAA. We've all heard about HIPAA. Whenever you go to a doctor, they make you sign 600 HIPAA forms nowadays. And even though you have a power of attorney and even financial and medical, and they both say that, whoever your agent is that you can talk to, sometimes you still they know that the doctors know that they face stiff penalties if they don't have HIPAA forms in place. So sometimes, they want that also. So we, as part of our packages, also make sure that HIPAA authorizations are signed. So the documents that you need are, a will, a trust for many people, not everyone, but many people need a trust. Um, there are, again, different types of trust. There's the special needs trust that we usually include in our trust. Will protect a beneficiary if they're on medical, on public benefits, and it won't kick them off if they inherit money. Powers of attorney, you need financial, healthcare power of attorney, a living will, and a HIPAA form. So let's talk a little bit about online documents, right? What's the problem with online documents? Well, let's talk about the story of the mushroom. Say you lived in a forest and you were going to pick mushrooms, and your goal was to make this massively amazing mushroom soup, right? And you pick all these mushrooms. Well, when you're picking the mushrooms, you may be picking the most incredible, most expensive, most decadent mushroom in the world. Or you may be picking a mushroom that kills you because you don't really know the difference, right? And that's sort of what happens with online documents. Maybe you're getting something good, maybe you're getting something bad. Like I said to you before, because we do estate litigation, we see a lot of the problems with these online documents that come in because they're defective or they weren't signed right or they didn't have specific state needs in it or they lacked tax planning and you couldn't do a variety of different trusts. You couldn't even figure out what the different trusts were. They were poorly drafted. You don't know what you don't know. And that's why, you should be very cautious in a situation like this of using online documents. Um, so that's just kind of a brief overview of the different types of estate planning documents you need. Um, we are always here to help answer questions. If you want to set up a consult, you can call our office at 856-642-6445, or you can reach us at info@Pasternak so it would be POSTERNOCKAPELL.com. Thank you so much for your time and happy estate planning.